you very much for inviting me in the international conference HSH 2020 Health, Social Science and Humanities, Enhancing Human Resources, Productivity to Engineering, Social Science and Health during COVID-19 pandemic. I want to introduce myself to all of you. Ahmad, business law lecturer, Binus University, and my research is legal subject interpretation of law number 18 of 2013 concerning the prevention and eradication of the forest destruction. The first introduction, I would like to say there has been an increasing trend of the forest destruction cases caused by the forest utilization and the use of the forest areas in manner which is inconsistencies with the provision of law or provision of law and regulations. Frequent destruction of the forest occurs in the form of the illegal logging and also unauthorized exploitation of the forest areas. Forest destruction does not only occur in the production of the forest areas, rather it also began to occur in the protected forest areas and also conservation forests. The research is based on the interpretation of the legal subject set out in the definition of the law number 18/2013 concerning the prevention and eradication of the forest destruction, or P3H law, namely organized individuals and individuals. The legal subjects to be charged is an individual, while the legal subject refer to the P3H law is person or persons acting on behalf of an organized association or on behalf of a corporation. Incomprehension or misinterpretation of the subject of the law can have fatal consequences. This law is intended for crimes committed by organized actor or corporation, while in the case study or decision of Sopeng District Court number 11/2018, the subject of the offense in the indictment filed by the public prosecutor are the farmers working individually. Ladies and gentlemen, the legal problem of this research is did they belong a certain corporation or company but enforce brought them to the court. I mean, the people stay around on the forest brought by the prosecutor as an offender, and according to the law, the offender of the law number 18/2013 is not individually but syndicate or organized crime. So this is the legal problem of this research. Elaboration and discussion. In P3H law, there are two categories of the legal subjects, namely individual and also corporation. There are two distinct categories, individuals and organized individual. The subject of the law is also mentioned in the several other articles in the P3H law. The meaning of the organized is also defined in the Article 1, Sub-Article 6 of the P3H law. Interpretation of the legal subject under law number 18/2013 concerning the prevention and eradication of the forest destruction. The first, this law is not intended to criminalize small farmers who live and settle in or around forests to undertake farming. The second, it's clear and evident from the general elucidation that forestry crime intents in this law are committed by forestry syndicate. Number 3, organized legal subjects can be identified based on Article 1, Sub-Article 20, which read as follows. Any person shall be an individual or corporation who commits organized act of forest destruction in Indonesia jurisdiction and or resulting in the legal consequences in Indonesia jurisdiction. The next, the P.3H law also provides an authentic interpretation of the term organized, namely as set out in the Article 1, Sub-Article 6, which read as follows. Organized shall be an activity carried out by structured group consisting of 2 or more persons and acting jointly at a certain time for the purpose of destroying forest, excluding group of the people living in or surrounding of forest areas that carry out traditional lodging and or lodging for their own purposes and not for the commercial purposes. The next, thus it's clear that this law is not applicable to the unorganized forestry crime, including criminal acts committed by the community group living in surrounding of traditional forest or plantation, benefiting from the forest for their livelihood. Traditional farmers who live in the surrounding of the forest or even in the forest who exploit forest for their livelihood have immunity against this law and cannot be treated as a subject of the criminal offenses. The next, I also want to analyze of the verdict number 11 2018 in Sopeng Court, South Sulawesi. This special crime case was decided on March 21st, 2018 by the panel of the judges at Watan Sopeng District Court, South Sulawesi. The first indictment, namely Article 82, Paragraph 1, Sub-Paragraph B, Junto Article 12, Sub-Article B of the P.3H law could not be proven because the defendants cannot be categorized as organized individual. The defendants are members of the traditional community and the falling out trees was not for the commercial purposes. As for the second indictment under Article 92 Paragraph 1 Sub-Paragraph A Junto Article 17 Paragraph 2 Sub-Paragraph B of the P.3H law, it could not be proven either that element of had been fulfilled because although the element of the defendant fall had been fulfilled, but the element of the legal subject was not fulfilled. Based on the analysis of the judge in the verdict, the charges should not have been filled because the legal subject intended in the P.3H law is not applicable to the private individual or individual. In addition to that, traditional communities are also an exception because according to the provision of the Article 1 Sub-Article 6, traditional communities living in or around forest areas do not fall into category of the organized crime. Hence, the defendant does not belong to the category. The last slide, conclusion. Based on the interpretation of the legal subject in the criminal provision under P.3H law, there are 3 types of legal subject, namely organized individual living in and or around forest area, and corporation. In interpretation legal subject, the article of the law concerned should be viewed as a whole. Consideration that the law is a special law. It needs to be considered from the all perspective, not only through the criminal provision of the Pid.Sus law, but also based on the purposes of the establishment of the Pid.Sus law. It is to minimize the cases of the criminalization of the communities living around in the forest, often subjected to the Pid.Sus law, which was in fact adopted not to the target such communities, rather than that it is aimed to organize crime. The last conclusion, it is consideration. The panel of the judges explained that in fact the element of any person in the case need to be proven based on the purposes of the adopting the Pid.Sus law, namely by using the method of interpretation of the reason for the establishment of the Pid.Sus law. Furthermore, it is refers to the consideration of the panel of the judges who interpreted the legal subject intended by the Pid.Sus law is an organized individual who actually consists of at least 2 persons or more, and not community living in or around the forest and cutting down the trees, which is not for the commercial purposes. The tribunal ruled the 3 defendants did not meet to the qualification as the legal subject, so they had not to be acquitted. The defendants are not perpetrators of the organized forest destruction crime as intended in the Pid.Sus law. I think this is my presentation and the result of my research. Thank you very much for your attention, and hopefully they have a question from all of you, and then I am very happy to answer the question or give clarification. Thank you very much.